Hello, everybody. Thank you so much for having us one more time in the show of the attorney Margaret W. Wong. Today, we're going to have one of the attorneys in the law firm. And just to let you know that there is an update in the website with two new attorneys that have joined the law firm, which is awesome. But today, we're going to be talking with one of the attorneys that you already know in this show, which is the attorney Anna Saleh. He's from the United States. He has been working on this field for over 10 years. And well, you can ask any question, family based petitions or family petitions, work visas, or you can also talk about immigration court. What's going to happen if you have an immigration case and you did not go to court? Today is a good opportunity to ask the attorney Anna Saleh about these kind of cases, especially when you don't attend to the court. What happens if you don't go to the second hearing or to the third hearing? Are you going to be deported? Are they going to cut you up in the court building? What happens in this case? So thank you so much, attorney, for having us today. And well, I would like to start by if you can share a bit of your experience with the court. Why do people miss court? What happens if I miss a court? What happens if I miss a court hearing for the first time and for the second?
So thank you so much for having me today. It's such a pleasure. It's always a pleasure to be with you and on this show. Now, immigration court is very, very important to attend your hearing. So there's a couple things that you got to make sure to do. First, it's very, very important that your address is always updated with the immigration court. There's a form called an EOIR 33, and that form should always be filed with the immigration court within 5 days of any address change. The reason why it's so important to update your address and make sure you have the correct address with the immigration court is they will send you hearing notices. Now, your court starts off by getting something called a notice to appear. And that notice to appear will tell you initially where the date is. Now, there's other ways that you can confirm when your court hearing is. You confirm by a 1-800 EOIR hotline where you can call in and put in something called your alien number, which is a number that starts with A. And those digits are very important because that's how you can track your case. You can also use the EOIR automated system, and you can check online when your court dates are. Now, if you miss a court, or if you're late to a court without reasonable cause, even 5, 10, 15 minutes late, there's serious, serious consequences. And those serious consequences can mean that you could get an order of removal in absentia, meaning you're not there, and you would have a final order that would remove you from the United States. In other words, your case is almost over. Your case is over. If you do miss court, you should see an attorney immediately, and you should document why you missed court, if you didn't receive notice or whatnot, and make sure to see if that attorney can file a motion to reopen or somehow to save your case. So again, the most important thing that you do is show up to court, understand where the court location is, and always keep your address updated with the court.
Thank you very much, attorney, for this answer. And well, we know that some people miss a court hearing, and now we have a question that is coming right away, coming right in, and it says, I received a notification that my court was on January 5th. Never received nothing, and it says I have an expulsion order. Where should I go? I have been calling ICE, but I don't know what to do.
So January 5th. So you only have a limited period of time to file a motion to reopen. One thing you need to do is you need to see an attorney immediately. Okay. And that attorney can potentially file a motion to reopen your case, and you can document why you missed court. Now, having that removal order means that if you see ICE, they could remove you from the United States. So my very, very important advice is immediately seek an immigration attorney that's skilled in immigration court and make sure they file a motion to reopen your case as soon as possible. You'll probably need an affidavit and so on why you missed court, and you need the discretion of the judge to reopen your case. So time is of the essence. You really need to see an immigration attorney right away and ask them for a motion to reopen your case. Because right now you have a removal order in absentia, which is really difficult because that means ICE can enforce a removal on you. And that also means that you're barred from any relief for 10 years. So, for instance, if I was married to a US citizen and I had an ability to adjust my status in front of the judge, or if my case gets terminated before the immigration agency, the UCIS, and get a green card, I'm barred from that relief because I missed court. So again, see an attorney immediately and try and ask them to file a motion to reopen your case.
Okay, thank you so much, Attorney Ana Sale. And if you have any question, please give us a call. The phone number is 216-279-3984. 216-279-3984 is the phone number that you need to call in the law firm of the attorney Margaret W. Wong. She's in Atlanta today. And since she's really, really, really busy today, she asked us to do the show with one of the attorneys that are awesome. So thank you so much, Attorney Ana Sale, for coming and joining us today. This next question is: my nephew and my son were detained in New York. I feel like they have been mistreated and they have not given them the chance to talk. My nephew was deported already, and my son seems to be waiting to be deported. Is there something we can do to stop this? To stop his deportation? He is 23.
Okay, so the important things you need to do is you need to figure out what stage that your son, for instance, is at with respect to the immigration court. If he had went to the court and already had his final hearing and got an order of removal, he had 30 days to appeal to the higher court, the Board of Immigration Appeals. And if he appealed to the Board of Immigration Appeals within that 30-day period, his order of removal to be deported is not final. He would have the right to have his appeal, and he would have the right to put a brief of his appeal. To the extent that he's already received a removal order and maybe missed those 30 days, there's still a 90-day period where he could file to the immigration judge to maybe reopen or reconsider his case. Now, if those days have passed, there's other things the attorneys can do, but the more time that passes, the more difficult it gets to stop a deportation, a removal, excuse me. Now, with respect to your son as well, he should definitely see an attorney and document the reasons why he feels like he was mistreated or wasn't able to speak up or whatnot. He has some rights under due process that could have been violated and might be grounds to reopen his case and get another shot to present his matter. Another thing that I would probably recommend as well is if he does have a removal order and that order is final, meaning he missed the appeal date, he could also have an attorney file a stay of removal with ICE, with the court, and that would stay his deportation, the removal from the United States. So again, motion reopen, motion reconsider before the judge, an appeal within 30 days to the Board of Immigration Appeals, filing a stay of the execution of the removal order. There's options, but you really need a skilled immigration attorney to help navigate it. But make sure you document everything that happened. For instance, if you ask for time to get an attorney and the judge did not grant you time to get an attorney, or you didn't have proper interpretation at the hearing, there could be a number of grounds that might result in you getting another shot at your case. But time, as I think will be the theme of a lot of these questions, is of the essence. Do not sit on your rights. The faster you go, the better chance you have to have another shot at overturning or making sure you get the best shot in your case and get due process.
Okay, thank you so much. We have something that we say in Spanish, but I don't know if it makes sense in English. Who punches first, punches twice. I just translated it. I don't know if that makes sense, but that's for people if, for example, you are boxing person, if you hit first, you hit twice.
Correct.
So if you go ahead and start doing something, you have the chance to do something in the second chance. So if you just heard this question, this answer from the attorney Ana Saleh, just give us a call. The phone number is 216 279 3984, 216 279 3984, and we will be happy to take care of your case or to listen to your exposition and then find a solution for your case if there is a solution. The phone number 216 279 3984, 216 279 3984. I was detained for no license and simple battery. I have no documents. My wife is citizen. Am I deportable?
Okay, so um, there's a number of things that you have to be aware of. One thing is certain charges will make you either something called inadmissible or it will make you deportable. So there's two separate ways, but either way it could end you up into court, immigration court that could lead to a removal order from the United States. Now, driving without no license, generally as long as there's no aggravating factors, usually don't fall in within those categories that will make you deportable or inadmissible. Now, simple battery can be a little bit more complicated. It depends on where you live, the statute, and the law, and where you live and how it's structured. The most important thing is do not plead guilty to anything, because in order to be removable, you have to have something called a conviction. So that means either you pled guilty or you were found guilty by a jury and the case was a conviction. Now, under the United States Supreme Court precedent and law, any non-citizen is entitled from their defense attorney to be advised of the collateral consequences of any criminal charge on their immigration status. So as a non-citizen, one of the most important things is that you have an attorney, a criminal attorney, and that criminal attorney under Supreme Court cases has to advise you, hey, if you plead guilty or you're convicted of this, this is the consequences that you face with respect to immigration. Now, if you have a wife that's a U.S. citizen, you may have eligible relief. If you came in on a visa, you might have an ability to adjust your status within the United States. And if you did not come in on a visa and you came in across the border without admission or parole, you still might have an ability through the I-601A process. So you have eligible relief. Here's the important thing for you to do. One thing is make sure you have a good criminal attorney and make sure that criminal attorney advises you on the immigration consequences. For instance, a simple battery, be very, very careful in pleading guilty or and making sure that if you do have to plead guilty to some sort of conviction, that it does not make you deportable. And again, your criminal attorney has to advise you on what are the consequences with respect to your immigration. Now, being detained and you have no status could mean that you end up in immigration court. If you end up in immigration court, you may have eligible relief because your wife is a citizen, either through the 601A process or maybe an adjustment of status process. Make sure you know that you have that eligible relief and make sure you ask for more attorney. Make sure you attend your court proceeding. Make sure if you get a notice to appear that you have that notice and you keep checking and making sure you show up to court. When you show up to court, if you don't have an attorney yet, ask the judge for more time to get an attorney and make sure you let the judge know that you might have eligible relief in that your wife is a citizen. So to kind of summarize, one, make sure that criminal attorney advises you on the immigration consequences. Do not plead guilty to something that you're not aware of the consequences, such as a simple battery, because that would be unfortunate because it may stop you from getting this eligible relief. Three, if you end up in court, make sure you get more time to get an immigration attorney and let the judge know you have eligible relief. And then finally, make sure you follow up on that relief. Because again, having a wife that's a U.S. citizen means that you might have two routes to getting relief. And it would be very, very unfortunate for you to miss out on something like that by pleading guilty to a criminal charge that bars you from that relief, or if you miss court and get an abstention order, which will bar you from certain relief for 10 years.
That's awesome. Your answer is awesome. Thank you so much,
Thank you.
attorney. The phone number is 216-279-3984. 216-279-3984 is the phone number that you need to call in order to get in touch with the attorneys in the office. 216-279-3984. Don't forget that the attorney Margaret W. Wong has offices in 9 cities of the United States: Atlanta, Chicago, Cleveland, Columbus, Memphis, Minneapolis, Nashville, New York, and Raleigh, North Carolina. And the phone number is just one: 216-279-3984. 216-279-3984. Um, let's keep talking about these questions that we have been receiving. I applied for Global Entry Program as a Colombian and was accepted. I had an appointment and checkup and was approved. I understand that when I go back to the US, I won't have to meet with an officer, but instead I would do the process on a device at the airport. Is this 100% guaranteed?
So just understand that nothing is 100% guaranteed, of course, but being part of the global entry program, it should make everything more smoothly. Now, with respect to immigration, though, specifically, my understanding is it depends on the visa category that you enter into and the visa. So, um, if you're coming in B1, B2 status, you still will have to be inspected and admitted into the United States. You'll get a stamp on your passport, and you can go online and get, if you fly in, and get something called a Form I-94. What's very, very important for you not to lose any disqualification from the program, you still have to comply with the terms of your non-immigrant status, meaning that you got to pay attention on your I-94 and your admission stamp on how long you're allowed to stay in the United States, and making sure you comply with all the terms and conditions of that status, and making sure you timely depart. So again, nothing's 100% guaranteed. To give you an example, even if I get a visa that's approved at the consulate or the embassy and I go to the border, they could reject me, but the probability is lessly, is not as high. So as an attorney, I just have to tell you nothing is 100% guaranteed, but um, it's favorable if you're part of this program.
Okay, thank you so much. 216-279-3984. 216-279-3984 is the phone number that you need to call to get in touch with the attorneys in the office of Margaret W. Wong and Associates. Um, I entered 3 times. 2 times I was sent back to Mexico and I made it the third time. My wife is U.S. citizen. Can she apply for me?
Okay, now there's something called the permanent bar. Okay, now generally, if you didn't have a if you, as long as you don't have a permanent bar, you again, what I spoke about before is you have an ability to either adjust your status if you came in with admission, like a visa or someone. If you didn't, you'd have an ability to do an I-601A. Now, what's going to be very important is you really need an attorney to review all your entries and how you were sent back, or it depends. So I'll give you an example, and the dates. Whether you entered in pre-1997 or you entered in after 1997, to kind of give you a hypothetical is, let's say, now you said you entered in 3 times, but 2 times you were sent back. So if you were sent back before you entered the United States from the port of entry, or you had a voluntary return, it can be concerning, because if I have multiple entries into the United States unlawfully, and if I occurred in the aggregate, meaning that all my trips over 1 year or more of unlawful presence, okay, then I'm subject to something called the permanent bar. Okay, that permanent bar means you would have to stay outside the United States for 10 years before you can apply back on something called an I-212 waiver that's discretionary, in order to be able to take advantage of a process through your U.S. citizen wife. Now, there's also unlawful presence bars. If you spent 180 days or more unlawfully in the United States and you left, then you would trigger a 3-year bar. If you spent over over a year, you trigger a 10-year bar of unlawful presence. So, kind of to give you the summary is it will be difficult to really tell you what she can do to apply or not. you do need a skilled attorney to really review your entire entry history. And again, a key date for you to understand is April of 1997. Okay, that is when these unlawful presence started to begin. So if you had early entries in the 1990s, some of that unlawful presence might not count. So what you need to do is you need to really consider how much time you spend in the United States unlawfully, and you have to also consider whether you ever received an order of removal back, whether it was something called a voluntary return, whether you took a voluntary departure. And again, leaving and entering the United States multiple times really puts you at risk for the permanent bar, which might mean you have to spend 10 years out before you can apply again on a Form I-212 waiver. So just be very careful, see a skilled immigration attorney, and make sure you document every entry and the dates that you entered and left, and really pay attention to that 1997 year.
Yeah, so this person is adding, I never left voluntarily. I was put back in Mexico 2 times.
So it looks like that probably means that he probably was in court and got a removal order. Um, that's difficult because when you do get a removal order, you are barred for a certain period of time. Like there's a 10-year bar on adjustment on certain eligible relief, but he said he's never got to court. Okay, so here's what he really needs to do. What you really need to do is you need to do a Freedom of Information Act request, a FOIA request for your entire A file, and you do that to the Customs and Border Protection (CBP), and you do that to ICE. And you need to take your file and you need to review your file and see what happened, whether there was a notice to appear that was sent to you and you just never got it, and you were removed in absentia, or if you were removed without any court. That's the best thing for you to do. Again, it's called a FOIA, a Freedom of Information Act request. You really need to review your entire file, and a skilled immigration attorney will be able to help you with that and requesting a FOIA of your file. Only then would I would say you really can get a definitive answer on what eligible relief you're going to be eligible for and how long you need to wait before you get that relief, as well as if you qualify for any waivers. Having U.S. citizen wife, spouse, excuse me, will definitely maybe provide an avenue for relief and maybe an avenue for certain relief. But I just would not recommend blindly going into it without getting a Freedom of Information request. That way, you know all your government records, you know all your entries, and you know all your encounters. That's the only way you'll be able to definitively decide on what eligible relief you'll have. Again, it's a FOIA, Freedom of Information Act request.
Thank you so much, Attorney Ana Sale. That's a very complete answer, and I think you have covered all of the areas that uh, a person could ask about this case. But if you have any other question, just please give us a call. The phone number is 216-279-3984, 216-279-3984. Next question is coming from a person in India or a person from India and says, hi, can I file EB3 for an Indian civil engineer?
And that could be possible if you go through the correct process, you have a sponsorship. So the EB3 category is a little easier than there's three main categories for something we call the perm process for a green card, work-based. There's the EB1 where this is the extraordinary and category. Then there's the EB2, and then there's the EB3. So an EB3 civil engineer definitely has a possibility, but you would need you would need a employment offer, and they would need to do something called a labor certification. They'd have to show ability to pay. And usually what happens in these situations, to kind of give you the sense of it, is, usually the company or your sponsor will hire an employment-based immigration attorney that will be skilled in this area and will be able to analyze your credentials and apply for you for an EB3. So usually you really need an immigration-based attorney that would help you through that entire process. Then from there, if you're outside and you're India, you would consular process. One thing I would not recommend, and you couldn't do, is don't try to enter in on a B2 visa, do an EB3, and then try to adjust your status, because a B2 is meant for a travel and going and coming back. It's not meant to go there and with the intent to have a green card. So if you have the intent for permanent residency, be careful, because you don't want anything to bar you from that. Also, if you come in and you overstay your status, it may affect your EB3 as well. So the most important thing is work with your employer. Make sure your employer gets a skilled employment-based immigration attorney, and they should be able to help you throughout that process. Now,
Okay.
also, you got to wait for visa availability. I apologize. And usually India is a little bit more backlogged. There's something called the visa bulletin. I apologize, I don't have the EB3 visa availability off the top of my head for India. But again, if you go to the US Department of State and you look at the visa bulletin for February 2023, look at the EB3 category, and look at India, your country of birth, as chargeability, there'll be a priority date there. So that'll give you a sense of how long you might have to wait for a visa to be available.
I just Googled it, and it says that it's not current right now, but it's around July 8th, 2022.
So it's not too bad. Some of them are backlogged for years. So start the process as soon as you can, so you can get an early priority date.
Okay, thank you so much, attorney. And don't forget, the phone number is 216-279-3984, 216-279-3984. This is a topic that is very popular right now in Latin America, with this parole for people from Nicaragua, Cuba, Haiti, I think, and Venezuela, which is the humanitarian parole. And someone is asking here, what are my requirements to become a sponsor for a humanitarian parole?
So you'll need to file. I apologize. My understanding of it is that you have to file something called an I-134. It's kind of like an affidavit of support. I don't have the exact requirements. I don't want to misspeak and put the exact requirements off the top of my head, but usually it's probably best to be a U.S. citizen or an LPR, a lawful permanent resident. Make sure you have stable financials that you'll have to fill out on that form I-134, and then you'd be able, and make sure you'd be able to document that. My understanding is you might have to show some tax returns, bank statements, or get a letter from the bank to show that you have sufficient funds. But if you have some stable financials, and probably recommended to be a United States citizen or lawful permanent resident. But again, I don't want to misspeak. If a non-immigrant could also to be an I-134 humanitarian parolee. But those are kind of the general requirements.
Okay, thank you so much, attorney. Our time is up for today, so thank you so much for all of the answers, for all the explanation. We know you have a lot of experience, but also the good thing is that you can explain to everybody what's going on, what is happening in the case of the immigration. Also, well, we are really glad that we get some time to talk about immigration. But if you have any other questions, please just give us a call. The phone number is 216-279-3984, 216-279-3984. Thank you so much, Attorney Ana Sale. Looking forward to see you soon, and have a good lunch.
Yep. It's always a pleasure. Thank you, everyone. Thank you, everyone who's viewing. And Han, thank you so much. You're absolutely amazing. We couldn't do it without you.
Thank you so much. For everybody, don't forget to call. The phone number is 216-279-3984, 216-279-3984. Attorney Margaret W. Wong and her office, with all of the attorneys that are really awesome and that can help you in your immigration case. Thank you, and see you next time.